Good morning. Happy Tamil New Year's Day. Uh, almost alternative subscribers of YouTube friends wanted to know how to disprove the will, what will be the differences, whether aged person writing will is valid or not. For all these questions, the judgment will answer AR 2022 Guwahati page 40. It is for better. AR online 2022 Guwahati 106. Ravindra Dugal versus Rajesh Kali and others. Though this judgment is of that Guwahati, there are about 7 cases or Supreme Court cases were discussed at various paragraphs. Under what circumstances this will should be proved and under what circumstances the court should consider that the will was not proved or not. Here they seems to have filed an appeal against the district court order rejecting the grant of bill probate title suit 3 of 2005. So they seems to have filed appeal under 299 of Indian Succession Act. The major problem here, they say, the issues framed before the trial court was whether the will dated 28/5/2000 alleged to have been executed by the deceased in favor of the plaintiff is genuine document on which the probate can be granted to the plaintiff. Next one, whether the deceased handed over the possession of her house or scheduled property to the plaintiff prior to her disposition from Guwahati to Amritsar in July 20. Next, whether the plaintiff had entered into house of deceased in January 2005 illegally. Next, whether the defendant is entitled to probate will dated sounds exhibit in favor of the defendant at Amritsar. Whether the defendant is entitled to recovering of possession of deceased property from plaintiff. So they have dismissed both the cases. They have dismissed the prayer as well as counter claim. Then they say 63-68 of Indian Evidence Act. The primary question which was decided by the court was the date of death, within 21 days writing will, the deceased died, and the date of death, the place of death could not be proved properly by the plaintiff. Here they say, what all are the circumstances peculiar? The natural legal heir were deprived. First thing, my friends, kindly note down this. Relationship between appellant and Jagdish Kumar Dugal was not been disclosed. Will did not disclose the relationship of the person to whom the property was bequeathed. Jagdish Kumar Dugal was admittedly suffering from terminal cancer at the time of execution of the will in favor of the appeal. Then the appellant does not properly know the antecedents of the sisters and other close relative of Jagdish Kumari Dugal. This is also most important. The appellant took prominent role in execution of the will dated 17/9/2004. These all are the things which they have decided. Then another important, apart from so many Supreme Court judgment discussion, needless to say that in any and every circumstance is not a suspicious circumstances. The circumstances would be suspicious when it is normal and is not normally expected in a normal situation, nor is expected of a normal person. This is what they have said. So kindly go through the judgment, keep the judgment on your file and record if you are really interested to defend the will or while probating will. You should be very careful about these defenses being raised, whether there is any possibility of filling up these lacunas or that could be a high profile advocacy. Best wishes.